Mark and Lindsay always felt they were living the American dream. Mark's dental practice had flourished over the years, and his investments in commercial real estate and a robust brokerage account promised a comfortable future for their two children. However, success brought a nagging realization. The more they built, the more they had to lose. To secure his family's future, Mark sat down with his attorney to build an asset protection plan using 4 core principles. Principle 1. Asset protection is the systematic process of identifying, quantifying, and mitigating risk. Principle 2. Asset protection is achieved by using tools, such as trusts and LLCs, processes, such as contract review, and laws, such as exempt statutes, to mitigate risk. Principle 3. A good asset protection plan will persuade a creditor that any judgment obtained may not be collectible as a practical matter. Principle 4. A good asset protection plan will place assets out of the reach of creditors and settle contingent liabilities prior to litigation. The first order of business was their $1,200,000 home. The risk of a creditor placing a lien on their home was a constant shadow. Fortunately, Mark lived in a state with a strong homestead exemption. Mark's attorney confirmed that 100% of their equity was exempt from judgments, effectively protecting their equity from creditors. Next, they looked at Mark's $5 million commercial real estate holdings. Between tenant rent defaults and slip-and-fall lawsuits, the risks were high. They installed a multi-layer defense. First, they moved the properties into LLCs to shield Mark's personal asset from business liabilities and shield each property's liabilities from the equity of the other properties. Second, they updated leases to require tenants to personally guarantee the leases, tenant indemnification, and tenant insurance requirements. Then there was the $2,500,000 brokerage account, the foundation of their children's inheritance. To protect it from writs of attachment or financial mismanagement, they placed the brokerage accounts into an irrevocable trust managed by a professional trustee, moving the money into a legal vault that future creditors couldn't crack. Finally, they addressed the source of it all, the dental practice. Mark faced 3 distinct tiers of risk. First, with unlimited risk for malpractice, Mark implemented standardized protocols and maximized his malpractice insurance. Second, to guard against risk from potential discrimination or harassment claims from his staff members, Mark's attorney drafted a comprehensive employee handbook and secured employment practices liability insurance. Finally, to mitigate the risk of insolvency, Mark restructured contracts with lenders and vendors to remove personal guarantees and pledges of collateral. Next, Mark entered into a management agreement with a management company wholly owned by Mark and Lindsay. By transferring cash from the dental practice to the management company, Mark is able to move cash from a high-risk entity to a low-risk entity. Through this ongoing and proactive risk management process, Mark protected Eric and Megan's inheritance and Lindsay's peace of mind.